What's up, everybody? Stephen Williams, founder and president of the creditrepairshop.com. I have to leave my door open here at my office because my employees might have to come in and ask me a question, but uh, I want to get this video done because there's a lot of stuff that has came through since I got back this week. And one of the things that I had some questions on here on YouTube was about Santander sold the account to the collector. What would the demand letter be in that situation? Like, what would we do? And we just prepared one for a customer, and what we would do is we would do two letters. Number one, we're going to send one to the collector because we're going to get them off of your back if you have a collector that the Santander debt was sold to. They need to be notified about the lawsuit, and that they're really supposed to be sending that debt back to Santander. If you've paid them any money, you should be getting your money back from them. The other thing is, uh, another question that came up was, and the letter sent to Santander to get the information removed off your credit reports. Um, Even if you're not in the state. Now, to be clear, this is for people who have lost the vehicle. They've been repoed, and you want to get the debt taken away, and you want to get it off your credit reports. That's what I'm speaking on right now. Uh, Another thing, from going back and forth and reviewing stuff, and uh, I had a good conversation with a individual on the phone today about Santander. And one of the things that popped into my mind, we've talked about before, where Santander was acting as the finance company and as a debt collector. And something that came to my mind, that on the reasoning why they did it. Now, we know that they want to do it as a debt collector, so they can, you know, make the phone calls and do all types of things that they can't really do as a finance company. And it is against the law in most states for them to be the finance company and a debt collector. I haven't seen a state that it is legal, but it could be legal for them to do it in some state. But they cannot do that. So right there have been lawsuits all the way up uh, to the Supreme Court that stated that they cannot be both, that they cannot do both, and that would basically overrule anything that a state had in place on on a finance company performing both as a finance company and a debt collector. So if you find yourself in that situation, and that gets to what uh, it came to mind, why would they, when you still had a vehicle and you maybe missed some payments and they charged it off, they have it as a charge off, and then but you still had the car, and they're sending you a statement as if it's just a regular loan. The reason why they do it, this is my educated opinion on this, is they do it so they can wipe out the car as being the collateral, and they are able to do anything with the debt. So if they don't get the car back, they're able to just start, a collection process on either selling it or continue doing what they normally do, which is collecting money as much as possible. And then if they can get the car, they get the car. It's like they're like hedging themselves. On one side, where they say, we're going to just charge it off and pretend like we don't even have the collateral anymore, and then we're going to come after it, but they have the person on the hook because they had the collateral. 'Cause just think about it this way: if it was a credit card company and they charged off the debt, what is the collateral? What is the actual collateral? Normally, when it comes to something that someone has collateral for, like a mortgage or a house or a car, in this case, they would go get the car, sell it, and then come after people for the remaining. And they would have it listed as a charge off. And the charge off would consist of the unpaid balance, and it would be no security. Because even if it's a mortgage, they would say that it was claimed, that the foreclosure was the property was claimed by the lien holder, which is the mortgage company. But what Santander has done is they've set up a scenario to where they don't, they charge it off and they don't have that they don't state that, and they are able to continue collecting, or they can sell the debt and not have to worry about the collateral. So this is crazy with what they're doing now. So, and I don't know what's going on with my webcam here, flickering on me. Another thing here is had a Facebook uh, message where they paid a debt collector that was past statute of limitations, and they feel like they should get their money back because they did not know that it was past statute of limitations. I told the individual you could still try to fight to get your money back, but this is what you could potentially run into is that when you deal with a debt collector that is collecting a debt that is past statute of limitations, once you pay anything towards it, a dollar on the debt, you start over the clock. So that's why you have to be careful. And there was someone that wrote uh, uh, a comment a while back that stated no one pays a debt that's past statute of limitations. This person here paid, I think they said they paid over nine or $6,600 uh, is what they ended up paying on a debt that they would not have to pay because it was past statute of limitations. And it's not about running away from your obligations. It's not about that. It's about if a company does not choose to come after you for a debt and it's past the legal statute of limitations, that company would use that same law against you if you were hurt in a personal injury and you didn't sue them within 2 years or didn't notify that you're going to be suing them. This is just your legal right. And if you don't take advantage of your legal rights, then what are your legal rights there for? So the statute of limitations are there for you to be able to have a creditor who is trying to come after you for a debt. If they don't actively come after you for a debt, get a judgment within a specified period of time. Every state is different. They cannot come and get the money. You can notify them that they're trying to come after you for a debt that is past the legal statute of limitations to collect in your state. There's a free letter that I got for you below this video if you believe that it is past statute of limitations. And all you have to do is click and get it. It's link below this video. And you need to also go to my website, thecreditrepairshop.com, so you can see what is the legal statute to collect a debt in your state. It's different in all states. All right, the next thing I got here, I got several court summons where people from here on YouTube sent them to me to see if there's something that can be done. We have our court response service, pro se defense service that you can take advantage of. But let me walk through these, and you can see if you're in this situation, if this applies to you. Um, First thing that I noticed on these sheets here is that the collection agency. Well, let's just start with step one. Step one is a lot of these complaints from certain states are not requiring the debt collection companies or the plaintiff attorney to disclose if they are actually collecting it for the original creditor, or are they collecting it for a debt collector, or are they the debt collector that's attempting to collect the debt that was bought from the original creditor. Um, I talked about it in a previous video last week where I had a uh, customer customer purchased the court defense program that we have, uh, but there was something that was not clear on the court summons. So I asked her to call them and to just ask simple question: do you own the debt, or are you collecting it for a debt collector, or are you collecting it? You're hired by the original creditor. Well, what happened was all of a sudden they sent this in the mail. I'm gonna grab this real quick. They sent in the mail. Now, this well-known collection agency was suing her. She owed, according to them, she owed $2,493. I told her I don't know if they are collecting it for the original creditor, or do it are they the buyer of the debt? Because some law firms buy debt, uh, or are they collecting it for another debt collector? And what she did, she said she called, because I said you're gonna have to call them, and she said when she called them that they did not want, they wanted her to give her personal information before they disclose anything. And she said she hung up the phone because she didn't want to disclose that stuff. And I said, you have to do that because by law they can't disclose anything to anyone without verifying that you are the correct person. But this is what happened because they record the calls, and you never know if it's something in their system to make sure that the representative that's answering the phone and taking the calls doesn't make a mistake that they can legally be sued for. That when they hear certain buzzwords, that that call may be sent up to the for someone to review in the office, or maybe they review all of the calls from their reps that they take every day. Well, what ended up happening is a few days later, they sent a notice to her saying that they're withdrawing the judgment, the request for judgment. They did that, and so that's why it's. I want people to understand this is the game that is played. The game number one is to make you think that the original creditor is coming after you for the debt. Most debt collection companies know and understand, and if you read through the court summons, if you read through it, one of the most important things that I look at when I see these is that I want to see number one, are they collecting it for another debt collector, or did they purchase it and they're trying to collect it, or are they working with the original creditor? That is potentially what would happen. But some of the things that start to pique my attention to make me think that stuff has been sold is when I see things like this where stuff is blacked out, where they black out account numbers. Usually, when I see that account numbers have been blackened out, is that the reason why is because it's been passed on. It's been passed around to other people. And that's what makes me think that. Other thing that makes me think it is that this account for this one here was a 2018. And all they did for this court summons was all they did was sent the warrant and they sent some bank statements. They didn't identify it. So potentially with this one, potentially, and I wrote back to you in the email if you want to get the pro se defense put together for you. The only thing we would need to know is we need you to make that call to see if they purchased the debt. Service is only $99. It's worth more than that. I was speaking to some other companies about that, and they were like, people do services like that for $599. Uh, with the one customer that I just showed you, we didn't even have to send the defense because just by her asking that question, it made them dismiss the case. And for the individual that said the dismiss is no big deal, um, if you got $2,400 hanging over your head and uh, they say we're not going to come after you for that 2,400 bucks, I think that's a pretty big deal, especially when they could have garnished your wages. Next one here is a major credit card company. They did the complaints. They did not disclose, again, did not disclose if it is the original creditor or the debt collection company. Uh, told this individual, we need you to do that. We need you to find that out, because if we can find that out, then the next step would be to submit the pro se defense on your behalf. Have another one here. Got a letter from a lawyer suing me for an account that was 2 years old. I have 30 days to respond if I agree. Number one, first thing you need to do is you need to see if it's is it from the court. Suing you has to be a court summons. They can say that they might try to take legal action, but that's a demand letter. A demand, and then that letter gives you 30 days to dispute. If they're saying you have 30 days, if you agree with it, that means that they're sending you a demand letter. So you need to do a debt validation, and if you got a letter like that, my free cease and desist and debt validation, the link is below this video. Get it, send it out. All right, let me get back to it. I had some unexpected visitors come to the office. Um, all right, where did I stop at? Okay, we had another one. We got another one that was a summons. You hereby are ordered to appear in court yourself, not a robot. Trying to sue the individual for $15,516. Sorry about that. All right. So again, $15,516. This one does state that that a debt collection company purchased a debt. They submitted the uh, debt buyer's collection affidavit, Supreme Court Rule 280.2. They submitted that, and let's see here. They submitted some bank statements with the redacted account numbers. Remember when I told you that one of the number one things that I see when a debt collection company purchases a debt is that they start redacting account numbers. That right there becomes a problem when you submit responses. How can you um, admit or deny to something that you don't have full information on? And so this is part of the defense when we put this together for people, is that uh, that's part of it. But basically, what you got to do is you got to answer the complaint. The complaint here is numbered 1 through 10. Uh, they even put on here that the suit has been filed within the relevant statute of limitations. One thing that I have been seeing is that every attorney's office that submit these, some of them don't. They might put one or two lines in the complaint. Some of them go all out. You know, they'll list all these things on here. Like they might, this one didn't say that the person lives in an address, but they'll sometimes state that the defendant lives at this address in this county that we're suing them in. Um, it's basically whatever they feel like they want to put in there to try to win. But this would be one that's a good candidate to submit for the pro se defense. I believe that this one would get thrown out. Uh, they would lose because there's a lot of problems with this one. One of the things here that they state. Let me just run through here with you. Let me share with you a little secret. Um, okay, well, when they do their affidavit, which has stayed here, Supreme Court Rule 2080 or 280.2, uh, they're basically stating that someone at the company, the person is a full-time employee at the original creditor's office, that they are familiar with the record keeping and practices of the plaintiff. But here is the problem. If the plaintiff is not the original creditor, who they listed on here, did that attorney, what is their full knowledge of this? Because the person who signed this affidavit here is not the one that's swearing to the information that's in the court summons. And so what they're doing is they're saying, on one hand, the original creditor, someone who worked in the office of the original creditor, knows everything about this account, and they told it to me, and I'm signing here on this affidavit. But the problem with that is that when that attorney that brought this case, number one, uh, they're making it look like that the plaintiff is the original creditor, but it's not the original creditor. And then when you ask them, because it's like they're trapping themselves. When you ask them that they review the information, has their attorney that is looking at this reviewed it, that makes them pull back and say, we didn't review this. We took their word. And how do we know all of this stuff is true? Uh, are we prepared to go into court and say that everything that that person said is true? And number one, we've signed ourselves off on an affidavit without even knowing that. And that's why some of the times it could just get dismissed right from the beginning when that happens, is because they're like, we cannot move forward. Maybe we might wait to get more information, but we can't move forward with this. That's going to be potentially some problems. All right. Well, I wanted to share these with you. Um, this is some good knowledge, some good information. If you find that you need help with the court summons, these are my ground rules for it. Number one, if they do not state that they purchased the debt in the court summons, that I'm going to need you to call them. You have to make that call and find out if they own it, or they collected it for another debt collector, or are they hired or contracted, retained by the original creditor. I'm going to need to know that information. And then the other thing is that you still have to be willing to go to court unless they send you, like what they sent the other client, documentation from the court saying that they uh, are dismissing the case. And then you need to give us at least a week to do this. Don't hand it to us when you got to go to court. in a day or 2 days. That's not going to work. We need at least 7 days before your court date so we can get the response put together and submit it. And we also need everything. We need the entire court summons, all of the sheets that they gave to you. We're going to need copies of all of those so we can read through them and make sure that we respond the right way. So I'm going to end the video here. If you need help with your credit, please visit thecreditrepairshop.com. If you don't have your credit reports and scores, remember everything starts there. Please use the website that I have, your3scores.com. That's one way that I help support the channel and to make the time to talk to everyone about this. If you need help with a court summons, pro se defense put together, there's a link below this video. If you need the cease and desist letter and the debt validation letter, I'm giving that away to you for free. Link is below this video. I want everybody to have a great weekend and thank you. And until next time, this is Stephen Williams, founder and president of thecreditrepairshop.com.